Hi, I'm Greg Dell, and today I'm with attorney Stephen Jessup, and we are going to talk about the disability insurance company Lloyds of London. Now, Steve, I know you've handled a lot of cases with Lloyds of London, and we find that most of these cases with Lloyds of London are private disability insurance policies. What is your experience when you get a claimant who calls you and they say, I've recently been denied or I'm having issues with Lloyds of London, in what your first thoughts are that come to mind when dealing with Lloyds of London?
Well, the first thing is that the policies are very specific to all types of things. Most of the times you don't see many Lloyds of London policies outside of athletes or the professionals along that line. So it's usually very contingent on the language, the length of the policy. Many of the policies are written for maybe a season, a year, whatever the case may be. So it's really all completely dependent on what was purchased, the product, the coverage, and more often than not, they're very prohibitive in the language and certain criteria you have to meet to be eligible for benefits.
So I've seen a lot of Lloyds of London policies for athletes, but I also see them a lot for executives and for doctors, and they're usually excess insurance policies, usually starting where a person either is getting a policy for maybe a 5-year benefit period for a high dollar amount, usually more than $15,000, or it's excess insurance for them where they already have $15,000 or $20,000 worth of coverage and they want to get another $20,000. But one of the things to me that's most unique about these Lloyds of London's claims is the fact that they use basically like a third-party company to administer them. Sometimes it could be a Peterson or a RMG, different types of companies that handle their claims, and they have very unique internal claims handling guidelines, even though they're individual disability. Like, for example, the case we recently had where the policy said that they could have one doctor review their claim and then another doctor who was hired by the insurance company, and then if they didn't agree, then they had to have a third doctor make the decision, and whatever that decision came out to be, that would be binding.
It was almost like a binding arbitration on the merits of the medical information.
And in my opinion, that's a horrible, horrible clause for a claimant, because you essentially end up with no day in court. You get a binding arbitration based upon a doctor, some random doctor who just makes up his mind. So when I see that situation, I love it when the claimants come to us first before they get involved in that situation, because after the fact, if this other doctor's already rendered an opinion, then there's not a lot that we can do. And I know in the past that we've tried to challenge the validity of this particular contract to say you can't have this binding arbitration. However, many courts have upheld this particular clause in the Lloyds of London disability policies. The other thing is that these policies that are funded by Lloyds of London, and the fact that, why is it Lloyds of London? Where does London come into the mix? A lot of people don't understand how that works. And I know that when we've been involved in these cases and we're trying to resolve them, that the claims people or the attorney on the other side are going literally back and forth to some representative in London to try to make a decision. And that could be difficult for somebody who is dealing with this claim, in the United States, where someone in London may have a different perspective on what the occupational duties are of the medical professional here. So, in terms of your opinion of the claimants that have been paid with the Lloyds of London policies, how difficult or easy of a process has that been when you've been involved with the claim?
I would have to say, more so maybe than other insurance carriers, that you have to be very detailed, because the policies are written in a way unlike any other standard, especially in the United States. If you buy from any of the main carriers, the language that's going to be contained in the Lloyd's product is completely unique to that product. And as you mentioned, with regards to medical reviews, things like that, you really need to make sure that everything's in order. The medical records are on point, the support of the doctors, what the occupational review is going to be. You really want to have everything done in advance, because they're going to be extremely, extremely thorough in their review.
Right. I think it's important to understand Lloyd's is one of those anomaly type policies where they're all very unique and different. And so if you have a claim, whether you're considering filing or you're dealing with them now and you're getting delays, which I find to be somewhat common because they're very thorough in their analysis and they're going to turn over every leaf before they even agree to pay you benefits. Or if your claim's been denied, you can call any of our lawyers at any time. We'll give you a free consultation and we'll let you know immediately whether or not we can help you. We look forward to the opportunity to discuss your claim with you.